Okay, so now this side of it kind of concentrates on more of the North Dakota, what a class action would look like in North Dakota, and what the certification hearing. Certification hearing is really, really, really critical. I think as time went by, the class action royalty owner attorneys, and there's a half a dozen of them in Oklahoma who are really, really good and who do this all the time. And of course, as with everything else, they kind of learned something along the way. And one of the things that they've learned is that to take more time at your certification hearing, because certification hearings historically were pretty easy in certain circumstances to get a class certified. And so they kind of rushed to the gun, got their certification done, and then later on down the road began to experience all types of problems. For instance, the first time, this lawsuit that I just referred to in Oklahoma was actually a part of there was actually two lawsuits. It was filed originally, I think, in 97. We took 17 wells out of the state of Oklahoma, and they were specific FERC wells. They all fit together very nicely. They were deep wells, and they had really high prices that were being able to be charged during FERC periods. And that was kind of our test case. I wasn't involved when that case was certified. I left the firm, and then I went back and started working with one of the partners again. And so I'm going to say that's my defense. There were 99 plaintiffs that we went out and found. And that's not a bad idea, because that way, if you have a lot of plaintiffs, even if you don't get certified, it's still a case worth pursuing. 99 people who had enough of an interest that would be enough to keep going. Problem was, they asked for certification of 99 class reps. That is a nightmare, because you had 99 people for discovery, 99 just folks on farms who put their check stubs in boxes and threw them in the closet if they kept them at all. And you had to produce, and you had to produce them for discovery, and then you had to produce them, and then you had the whole issue of how adequate representation they were going to give. It was crazy. Nightmare. So once that suit settled, we tried that for 5.5 weeks in 2005. And the case settled. And then it moved. We then moved into the second phase of the lawsuit, which had been stayed, which is the 3 state. All the other wells, I think it's like 18,000 wells or some crazy number. But it involves New Mexico, and there's a lot of coal bed methane gas in that part of it, Texas and Oklahoma. That was my last effort before I left and went and did some other things, is the class certification hearing. That time around, we went through and found 2 or 3 who we thought were really, really really top-notch representatives for each state out of the 99 plaintiffs. And so when we went to certify, no one had ever really thought about that. Just because you're a named plaintiff, do you have to be a class rep? And the best answer we could find was no. So once we had the class certified, then all the other plaintiffs became class members and kind of nominal plaintiffs, and we got to set them aside and only go forward with our 6, and we only had to put 6 or 7 or 8 or whatever it was. We only had to put those on for deposition, those on at class certification hearing. Class management just went so much better at that point. So it does make a lot of difference, how you approach these things from the beginning, from the very beginning. Just as an FYI, how many in the room, absent my students who get to see this every time I have a class, have seen this satellite image? Quite a few of you should have. This is a satellite image that there was a geographer, a novice, and he spent a lot of his time, I'm losing the word, looking at these satellite images, and he found this image, and wondered what it was, because if you look a little bit to the south, it's kind of black there. So he did some research and found out it's the Bakken. And you can see I-94, if you're not familiar with North Dakota, it runs, 94 runs over through Bismarck, and then it shows Fargo. I think if you can look up a little bit further north, you can kind of even see Grand Fork, and I think far up north is probably Winnipeg. So this was an area that probably 10 years before that, or 12, 14 years before that, was as dark as what was south of there. And there's 3 causes for that. One of them is the lights on the rigs. One of them is all the extra lights being generated by the man camps. But a large portion of it is the flaring of natural gas. About 1/3, the last number that I knew, 1/3 of the gas that's produced, because when you produce oil, you produce gas. And so about 1/3 of the gas in the Bakken is being flared. And there's a couple of reasons for that. One, the price of gas is so low that there's just not the incentive. If you've got gas at a couple of dollars an MCF and you've got oil at $100 a barrel, you can throw away the gas. And the pipelines aren't there, the infrastructure's not there, the gas processing plants are not there. That's why this One Oak plant is so important. And as time goes on, and we see the infrastructure put in, excuse me, then, and as gas prices will rise again, then there's going to be more of a demand for that gas. And so while this topic is primarily about gas production, it's really kind of the time to be thinking about it. If you're a producer or if you're a royalty owner, now, not 10 years from now, whenever the gas has already been sold. Which raises the question on the duty to market. Can you flare 1/3 of the gas under your lease? No. Okay. I have given it thought. Is it a breach? I wouldn't go out there and try it right now. Okay, so the next slide is just some numbers. This was the 2005 number of barrels of oil in the Bakken, and I'm just trying to get some perspective on this stuff. So that was for the month of December of 2005. By 2010, it had gone to 10 million. By this last December, the preliminary numbers are 23, almost 24 million barrels of oil a month. Put that in perspective, Oklahoma is producing about 8.4 million barrels. Texas is producing, and this was the December number, 68.82. Oklahoma is primarily a gas state now. But that kind of puts it in perspective of what is going on out in the Bakken. And you guys, a lot of you have seen this, but maybe not all of you have. So the numbers are really astronomical, and they're just not going to change in any great soon hurry. So that kind of gives you kind of a frame of reference of what's going on out there. So and the gas numbers are large. I didn't put them down here, but they're not small numbers. Even what's not clear to me, and I haven't asked, the North Dakota Industrial Commission puts these numbers out every month. It's called the Director's Cut. You can go to their site and get it. It's very interesting. And I haven't asked if the numbers they're giving includes the flared gas. I believe it would not, but I don't know that. So I don't know if the numbers include the flared gas. But they're not small numbers either. So getting on to class actions, the federal rules, and I was surprised to find out how North Dakota is, like a lot of things, a little bit different. Not bad different, just a little bit different. So they follow the federal rule in their analysis. It's very similar. Most states do, but they do have some changes that are pretty substantial. So in the federal rule, just as a little oversight, you have 4 prerequisites. The number one is that there has to be what we call numerosity. that the class is so numerous that it would be inefficient. There'd be reasons not to pursue each case on its own. It would clog up the courts. It would make it impracticable to join everybody. You have commonality, where is, if you have questions that are common questions of law or fact, that's one of the prerequisites. Typicality, those are often talked about. Commonality and typicality are very so closely related. The question is are the class reps' claims typical of what else is in the class? But those, so often when you read the cases, they really haven't done a very strong job of distinguishing the difference between where there's commonality, you usually have typicality. And then the fourth one is adequate representation. And that kind of goes into that, what I was talking about earlier, about the numbers. One thing you want to watch out from, if you're from the plaintiff side, you want to watch out for sophisticated royalty owners as a class rep, somebody who participates in, we had one of those in the 99. That wasn't in the next case when we went to certify. If there's somebody who's very sophisticated, then you're going to have a harder time on a discovery rule argument. So those are issues, and if you're defending one of these, that's what you want to look at. How sophisticated are these? And now, especially in states like Oklahoma and Texas, royalty owners are becoming pretty sophisticated, and so they're tougher and tougher to argue. But Mom and Pop just relied on the company to do what they were supposed to do. Under the federal rule, you have three types of class actions. So the first one is, if it would create, you're looking in, these are again, what you could have one that it would create separate actions would create a risk of inconsistent decisions. So that is a basis. You don't want inconsistent. You don't want one guy going to court here with the same claim as Farmer B, and they end up with different results because they're in different courthouses. So that's one way that we look at class actions under the federal rule. The number one, A and B, or would they be dispositive? So are you going to get not res judicata because it's different parties, but once you've litigated this issue, is that going to be dispositive for all the other members or all the other people who have the same claim? Those are the plaintiffs. That one's a plaintiff type. The second one is a defendant's side. Is this party has refused, continues to refuse, has acted or refused to act on grounds that are general to the whole class, i.e., paid everybody the same. If they paid everybody the same, then that's an action that would say that that are generally apply to the class. And then the third is common questions of law and fact, and this is what typically under the federal rule is what we see as the type of class action that's certified. Is it's common questions of law or fact predominate. So we look at individual control by different plaintiffs. We look at other ongoing litigation. Is there other litigation that's already going on in another jurisdiction, another forum? Is this forum desirable? And this comes into play a lot if you're trying to do a multi-state. That becomes a bigger issue. And how difficult is this class going to be to manage? If it's going to be, the nice thing in today's world, as far as one of the big issues is number crunching. And because of computers, it's just not as difficult to crunch numbers. It's really expensive, but it's not difficult as far as a computer is concerned. So that's under the federal rule. The North Dakota rule is similar, but it's different. They start out and it just says, the statute says it's so numerous that joinder would be impracticable, and there's a question of common law or fact. So that's the basic. However, then, and the B is you're supposed to have a certification hearing as soon as practicable. That's pretty much, that's true wherever you're at. It just depends on what is as soon as practicable, how much discovery should be allowed before you need enough discovery to kind of flesh out the issues, but if you do too much, then you've spent all this money and time, and then you don't get it certified, so it's a kind of a juggling match. But here's where North Dakota gets interesting. Their criteria, there's 13 factors that have to be considered. And there's only really 2 oil and gas class actions that I've been able to find in North Dakota. And so I'm going to go through those 2 here in a minute, but there's only 2 to consider. And they kind of give us some guidance on this. So these are there's 13, and I'm not going to read all 13 of them to you. But we've got, this is A, 23C1. Is that right? I can't read sideways and backwards. Okay, so relevant factors. Joint common interest, create risk. Separate actions would create risk. Class members would be dispositive, all sounding very similar. Has the defendant acted or refused to act? Common questions of law and fact, whether other means of adjudicating and defenses are impracticable or inefficient. Whether a class is the most appropriate means of adjudicating the claims. Non-class members have a substantial interest in individually controlling. But the one that's kind of different in myself is M. You have, has it already been litigated, the desirability of the forum, management, unusual difficulties, pose unusual conflicts of law, create unusual difficulties. But there's 2 of them that are really kind of different. The first one is that joint or common interest, and that gets discussed in one of these cases. You don't see that joint or common interest issue. And then this last one, whether the claims are insufficient in view of the complexity of the issues. So, and I didn't look to see when that was added. That might have been something that was added to get some of these coupon cases and things like that, get rid of some of that stuff. So for the most part, the 13 factors are also in the federal rule. They're just kind of fleshed out a little bit differently. So the cases that deal with it in North Dakota, the first case is what I call Ritter I. There's actually 4 Ritters. That's another thing. These take a life of their own on. This was the appeal. This kind of sets out the facts of the case. And this was about 6,000 members with 2,300 wells. And this was one where Koch sold the oil, and this is an oil case. And it was when they were measuring it by hand. They had hand gauging. And it actually came out of a tax commission case. The tax commission had come in and decided that they weren't quite reporting all the oil that they were producing. And so based on that, the royalty owners came in and filed a class action. So it was originally filed in 1996. So here we are on the first appeal of the class action. And this is what the court said as to the 13 factors. It said they had to weigh them. They weren't all equal. They weren't, they didn't have to find all 13 of them necessarily. So that's, the court does say you have to kind of go through and look at them all, though. On the commonality question in Ritter I, they took the standardized conduct by the defendants. So it was the defendants treated all of the plaintiffs the same. It was a uniform conduct throughout. So it was a single type of transaction. They purchased North Dakota crude, the single purchaser, and it was a single commoditor. So that they said that gave it the commonality. But then they ended up reversing it on number 1 and sent it back because they said that the court, it was an abuse of discretion case, and he had certified it on the commonality. But then he went on and they found this joint or common interest, and the Supreme Court said that there wasn't sufficient evidence in the findings to determine whether there was a joint and common interest. Not that he had to, but since he did an analysis of it, he had to do it correctly. So they sent it back. So then it comes back up for Ritter II. And on Ritter II, they said that the trial court had done a fair and efficient adjudication of the controversy in Ritter I, had a common interest. If Koch has to return profits, Koch's liability would not depend on how the profits would be distributed, still found a common or joint or common interest. So in this, now the argument is this fund, this money, this 750,000 barrels of oil. Koch was arguing that there's no joint or common interest because everybody had their own piece of the pie they needed to get. The plaintiff's argument was that it's one pool, and regardless of how it's distributed, Koch has no real interest in how. And because they didn't measure it at each well, they couldn't trace the product back to each well, that it would be done on a proportional basis. So that created this joint or common interest. And so the North Dakota Supreme Court now affirmed and said that it had earlier recognized that the trial court doesn't have to analyze all 13 factors, but has to analyze them correctly. If you analyze them, it has to analyze them correctly. So then the question kind of becomes, at that point, if you didn't have to have a joint or common interest, if these other factors were enough, why were they pushing to keep this joint or common fund? Well, one reason might have been, and this is another little quirk of North Dakota class actions, is you have a mandatory class under certain circumstances, which means you can't opt out. So, and the joint or common interest is a mandatory. So if you're in this mandatory class, then you can't opt out, and that would be what a plaintiff would, the attorneys and the class reps, they don't want people opting out, because the bigger of course, in this case, it may not have mattered because there was a set 750,000. But if you opted out, and anyway, it's probably more information than you would even want to have. But it created this common fund, and then you had to stay in. It made life a little different. Koch defended that, saying, look, a common fund, a mandatory is unconstitutional. It's not due process. And North Dakota, the Supreme, said, no, it's okay. You have that covered because you're guaranteed that non-representative class members can come to court and have their own day. They can be part of the suit, which is just unheard of. Could, in my mind, would create crazy. If you had at the litigation stage, you had class members coming in and having their own counsel. But that is allowed here, and so the Supreme said because they have that opportunity, even though they can't opt out, they can hire their attorney, they can come to court. So therefore, they're protected. So that would be one reason that they might want it, is because they wouldn't be able to get out on this mandatory class. And if it were a case where there wasn't a sum certain, this would be a sum. I mean, you have 750,000 barrels. But in a case like we had in Oklahoma, where if you opt out, then those people's interests are out of the suit. And so therefore, those are less damages that you're going to end up proving at the end of the day, i.e. less attorney fees, less rep fees. So you want to keep your people in. So Ritter II, then we go on to Ritter III, where it came back. Now this time we've got the class, it's been certified, but now we're up on summary judgment. And Koch was defending that there should not be, they should not be allowed to have a claim for conversion because this is a contract case. So they lost that argument because the court said that you can have, it's not incompatible to have a contract case and a conversion case. And the fact that they just didn't pay is more than just a contract issue. these issues of conversion, unjust enrichment are big cases. They didn't find for the unjust enrichment, though. They said that was incompatible. And they also argued that they should not have an accounting, but based on the conversion claim, they said they get an accounting. And those are big cases because for a plaintiff, because you want to try to get outside of your contract so that you have your tort remedies available to you, which increases the case if you have to try it, but it also increases the settlement value because you're at risk. This is what they said on the conversion case. When you deprive the plaintiffs of excess unreported oil, then that rises to the liability independent of the contract. But then they said unjust enrichment only applies in the case absent the contract, so they went along with the trial court on that one. And then they said they got an accounting based on the conversion claims, gave them an equitable basis. So that was and then the fourth, I didn't really go into the fourth Ritter case, because the fourth Ritter case is they settled it. After this summary judgment, now the defendants know what it's been appealed, so now we know what we're going to have to go to trial on. So now we can sit down and talk about settlement. And that's often the way it goes. A lot of times it's after the class action has been certified or after summary judgment motions, because now we know what's left and we can get down to what's the value for that. Because most of these cases do not go to trial. Only moi gets to do that. Well, it's like living in western North Dakota in a small hotel for 5.5 weeks when your family is not in Bismarck. It was not fun. But we did it. So, standardized conduct, that's what got you. So this was a field-wide certification in BICE. They also sought some declaratory relief. So that's what's going on in BICE. That, the language, they're alleged to have calculated royalties in the same way regardless of lease language. That's what happens. Approximately 100 had already sued Petro Hunt. So we already had 100 people who had done it. So this was time to come up to the class action. Again, it said the court's not required to address all 13 of the factors. It has to weigh them. But as we saw in Ritter, if you talk about it, you got to get it right, or we're going to make you do it again. The question that came up then on BICE 2 is the marketable product rule. And this is then on summary judgment. So now we're past class certification. Now we're at summary judgment. And this is where the North Dakota Supreme Court said we join the majority of states adopting at the well. So they went with Texas. They're saying that you get to go in and deduct back whatever the net back. You go out, you see what you sold it for, and then you back in what it cost you to get out there. So they have adopted that rule, which will really, really, really ratchet down the opportunity for plaintiffs' lawyers to make class action claims in North Dakota on gas, because this is just where your big ticket item is. This is where if you can get the courts, because historically in that on the way they calculated royalties, they all deducted them all the way out, and so therefore now you have to give them all back, and it turns into a lot of dollars. So what's left after in North Dakota? Now that we don't have marketable product rule, you could still have what information is required to a company. You have this. You're going to have some other underlying claims, like you get to deduct the post-production costs, but did you deduct them correctly? Did you take too much? They even actually I think it's in BICE. They actually got to deduct depreciation, but they had an agreement, so that may have been Ritter. So this is all that North Dakota requires. It says you have to identify the amount of oil and gas sold, and the amount and purpose of each deduction. So it says you got to put the deductions on there, put the deductions on there. If you put the deductions on there, like I said, North Dakota has a discovery rule. The discovery rule then at least allows you to get a statute of limitations issue instead of because they're going to argue some type of a tort action, and if they're successful in getting the tort action, then they're going to also be probably successful in the discovery rule, which then leads you into 1971. That's a lot of years of post-production, or however long, 10 years, but especially if these wells have been producing for any length of time. You also have your interest on late payments. Oklahoma has a really nice, nifty, neat statute on this, but North Dakota's is simpler. You have 150 days up here to pay. Oklahoma has 60 days. So if you pay late, then you pay 18% interest. However, unless there's a title issue, then you don't have to pay at all. I mean, there's no interest due at all. So if you can create a title question, then you may not have to pay any interest. In Oklahoma, it's 6% if you have a title issue. You're still having to pay interest until you get that issue resolved. If it's not a title issue, then you have to pay 18% or 12%. Now, see, I'm forgetting. I've been in North Dakota too long. I think it's 12%. So there are some exceptions for the 18%. So this is usually not a big ticket item, but if you're looking at class actions, the reason I always really advocated for late payment is because if it's there, it's there. It's really easy to calculate, and it keeps you from getting a risk of attorney fees from your defendant. So this is one of those issues that grab onto it. But 150 days is a long time. And you also have the exception of you only have to pay twice a year if it's less than $50. So that's an exception as well. This question is not answered in North Dakota, whether there's a fiduciary duty owed. In Oklahoma, there's a long-standing cases that say that if there's a unit, if it's a compulsory unit, if you've used the police powers of the state, then you have created a fiduciary duty between the operator of the well and the royalty owners that will and overrides. Maybe not overrides, but the royalty owners. So this gives you, if you can create that fiduciary duty, it by itself doesn't create any damages, but it gives you that tort, that higher standard, gives you punitives, it gives you an opportunity for punitives. North Dakota has not determined this issue, whether a unit operator or any operator owes. Now this is separate and aside from joint operating agreements and what duties might be owed under that agreement or under agency relationships, but just under the royalty side of it. There might be, there are cases on the other side. And then this case is an oil case. It's not a class action. So and this just talks about affiliate transactions. This is the other section of class actions that have gotten a lot of use historically. And again, we kind of go through different, we went through take or pay, we went through different stages of things. We went through this period of time of affiliate transactions. And it appears that North Dakota would not be unlike just almost every jurisdiction that says that you have to have an arm's length transaction. And so before you can start calculating royalties, so you can't sell it to an affiliate. So this is one where Koch bought and processed the gas and sold it to used an affiliate so that they could buy it at a lesser price, and then that's what they paid out on. And so they said, no, you can't sell it or buy it at a lesser price through an affiliate, and then count that as an arm's length transaction and calculate royalty from it. Oklahoma's case on that is Howe v. Texaco, which makes what I'm trying to get at a little clearer. And that last line is really the most important, where I've highlighted it. We hold that an intracompany gas sale cannot be the basis for calculating royalty payments. So you have to, in the middle it says when a producer is paying royalty based on one price but is selling the gas for a higher price, the royalty owners are entitled to the higher price. So it's really kind of a common sense idea. And I've seen companies who had affiliates who didn't even have an office, didn't even have a checkbook, barely had an address, and yet they were using them. Big companies, these weren't little guys. This was pretty substantial companies. And so affiliate transactions will get your client, if you're representing operators, into a lot of trouble if they don't do it correctly, don't pay attention to what an arm's length transaction is and whether they're conducting it that way. It's always amazed me. You give them 1/8 back in the day, but 1/8 was never enough. I still had to get a few pennies off of that 1/8. That's my royalty owner side coming out in me. Okay, so the last thing on my set was this adequate representation. I've already talked about it. I already told you the experience with the 99, quantity versus quality. Defining your class is crucial. You may want to exclude sophisticated, working interest owners, companies that own. They're going to opt out. Well, not in North Dakota. If it's a mandatory, they can't opt out. But it would be really hard because these companies own royalties. And so you have somebody, you're suing Continental on a royalty owner class action. They have some royalties in your suit. It's a mandatory class, and they come in and participate in the suit. Well, that'd be fun with their own attorney. There's conflicts that are going to arise in that. So you can narrow your class and just take out industry people. They're just not part of the class. Give that, those are things that people need to give a lot of thought to before you start writing these class descriptions. And again, look at your reps and say, how much do you really know? And I'd hate to have a $66 million lawsuit go away because your class rep knew too much, was too smart, and that's what happens. So that covers, I don't know how much time that took. Are we on time? Last time? Do we have any questions? I'm tired of talking. But I'll answer questions if I have anything of use to say to anybody. Do I have any practical advice if you've never done it and you have a client that comes in and you think you might have one? Yep. Go find somebody who's done them before. Well, and the truth of it is that you're going to have to anyway. If you have a class action that's really worth something, you, as a plaintiff lawyer, you need to band up with some other attorneys. We had 6 or 8 independent attorneys. Every time we went to hearing, there'd be 15 attorneys. We had, in this last suit, we had a judge who had a rule that if you wanted to be in front of the bar at trial, you had to come to every single hearing. Scheduling conference, it didn't matter what it was. You had to, and it was 2.5 hours for us and 4.5 hours for some of the other guys. And 2 guys came from Austin, and 1 guy came from Houston, out to Western. It'd be like going to Dickinson. So, and so everybody tramped out there. Very, very expensive. But these companies, I mean, if you're a royalty owner side, they're going to have the big guns, and you're going to have to play with the big boys and girls and be able to hold up with them. And we were able to, but you can't. Very rarely are there small plaintiffs lawyers who can do that. So you're going to team up anyway and get people who know, get them for different reasons. We were the oil and gas people, but we weren't the trial people. Didn't have a lot of trial experience, so we got a really good local trial lawyer who was known in the county. So that would be my practical advice. And they're very, that suit, there was $1.6 million in out-of-pocket expenses that we paid out of pocket. Not overhead, not salaries, deposition, travel. They're very expensive. Can be. Anything else? Yes, ma'am.
I'm just curious about the numerosity factor. How
There's no set number. I think back when I was looking at those issues, and I meant to look at that here recently, but there's been classes as small as 15 to 17 people. But by and large, I mean, that typically turns out to be a joinder kind of a case. There have been cases of working interest owners that have gone against. There's been class actions, but usually that's like if you have an operator such, and don't get me wrong, I like Continental. So I'm just using them because they're up here. I do. They're a good company. They're started in Enid. They're an Oklahoma company, and as far as I can tell, and you guys would know better than me, I think they're doing a pretty good job up here. But let's say, Continental might be sued by operators not in a lot of different wells, not just one well, and come together as working interest owners because of the practice of something they did that went uniform across their whole business. So you could have working interest owners, but it can be pretty small. But I would say typically in these class actions, they're several hundred to several thousand in oil and gas stuff.
Okay. Well, I'll go again with one more question.
Oh, okay.
Do you have any advice for thinking about how you strategize for subclasses?
For subclasses. Well, those sometimes they fall naturally. This case that's ongoing, there's a subclass for Oklahoma, New Mexico, and Texas, and you have to do that. Kansas just had one that was overturned because they were using Kansas law for everybody. That's never going to work for a multi-state. You want to think about maybe different lease languages. Maybe there are some differences that you need to separate out. So those kind of fall. If you give some thought to that in the beginning, it's better to do it in the beginning and be prepared to offer up. These are some subclasses. The judge has a lot of ability to change that back and forth as the suit would go on. So I suspect there'll be some coming down the road up here some eventually.
Any last questions for Professor Fritze? Okay. All right, well, we're going to break until 3 o'clock, and I welcome you to help yourselves to some beverages and cookies over there. Thanks.